How is everybody? Today is Tuesday, November 25th, and I am back to finish reading to you the Aaron Spencer updates for the Aaron Spencer case. He is the father of the 13-year-old young lady who was groomed and SA'd by a 67-year-old man named Michael Fossler. And Michael Fossler was shot and killed by Aaron Spencer after kidnapping and reoffending, after kidnapping her in the middle of the night from her parents' home and essaying her again. Aaron Spencer is for second-degree murder, and there have been some motions and whatnot filed in the last couple of days, or actually yesterday, I should say. And I read most of them, but there's still a couple left to read. If you would like to help Aaron Spencer's family with counseling expenses or his defense, you can contribute at his Give Send and Go at Give Send and Go Aaron Spencer, and I will post the link at the bottom of this stream. So let me see. Let's start with, well, where we left off yesterday. How's that? This is going to be a quick stream. I just wanted to jump on here real fast while I had a minute. But I will be coming back on either tonight or tomorrow to go over the Kelsey Fitzsimmons hearing today. I got to tell you, that judge, I don't know if he's any better than McCarthy. Is that her name? Yeah, he was a ball buster. Let me tell you, Timothy Bradel couldn't catch a break. This guy was a so we'll address that when we go over the hearing, and that'll be either tonight or tomorrow. Okay. So, let's try this. Share screen. Share. I'm going to make this bigger for you. Okay. So this is a brief in support of motion for individual or small group sequestered voir dire. The defendant, by and through his attorneys, Aaron Casanelli and Michael Kaiser, states for his brief in support of motion for individual or small group sequestered voir dire. For the reasons stated herein, Spencer requests that the court permit counsel to conduct voir dire of prospective jurors, individually or in small groups, outside the presence of the remaining panel, that the jurors who have been questioned be sequestered until the jury selection is complete, and that prospective jurors be admonished not to discuss the case with each other. Spencer is charged with second-degree murder with a firearm enhancement. The case involves the killing of Michael Fossler, who SA'd Spencer's daughter and who, despite facing 40 pending felonies related to that abuse, picked her up in the dark of night to continue victimizing her until Spencer intervened. Spencer has raised justification defenses, including that he reasonably believed Fossler posed an imminent risk of harm to Spencer's daughter and to Spencer himself, and that the force used was necessary to avoid that harm. The subject matter of the case, SA of a minor, parental defense of a child, and the question of whether Spencer's use of force was justified, alone warrants individual or small group voir dire. Prospective jurors are likely to hold strong personal beliefs about child SA, parental protection, and self-defense. Both parties will necessarily explore these topics. Because these issues are deeply sensitive and highly charged, jurors may either influence one another's views during group voir dire or hesitate to share their true feelings in front of dozens of community members. Either outcome risks distorting the voir dire process and undermining the court's ability to seat an impartial jury. The case has also received public attention due to its subject matter and because of prior proceedings, included review by the Arkansas Supreme Court. In addition, several individuals connected to the events live in Lonoke County and may be known to potential jurors. It's a really small county. Members of Spencer's wife's family and Fossler's family have deep roots in the community. Both Spencer and a key witness, Sheriff John Staley, are candidates in further publicity. These circumstances increase the likelihood that prospective jurors have been exposed to extrajudicial information on hold strong opinions that could influence others if expressed in a group setting. A more searching inquiry is possible during individual or small group voir dire. Complete and candid answers are far more likely in that setting than in large group questioning. Individual questioning is essential to identifying biases or preconceived opinions, free from the risk that jurors adopt answers they have heard others give, conform their responses to group expectations, or avoid expressing sensitive views in public. Moreover, when prospective jurors explain what they have heard about the case, they often repeat details that may be inaccurate, inflammatory, or inadmissible. Doing so in front of other prospective jurors risks training the entire panel. It is crucial to determine what prospective jurors know about the case, what opinions they hold, and whether they can set aside that information and decide the case based solely on the evidence and the law. Conducting that inquiry in the presence of the full veneer, however, risks contaminating the panel and jeopardizing Spencer's right to a fair trial. Counsel cannot meaningfully explore these issues without individual voir dire. The failure to do so would deprive Spencer of effective assistance of counsel and of his federal and state constitutional rights to due process and an impartial jury. The United States Supreme Court has long held that a juror must render a verdict based solely on the evidence presented in court. The right to an impartial jury necessarily includes the right to take reasonable steps to ensure that impartiality, period. Voir dire is the mechanism by which challenges for cause and preemptory challenges are made meaningful. Without a full and adequate voir dire, these rights are illusory. I don't know what that word means. Courts have recognized the importance of individual voir dire in cases involving substantial publicity or sensitive subject matter. And I would say that this case has both. The ABA standards for criminal justice likewise recommend individual examination when exposure to prejudicial material is likely. That word is so hard for me for some reason. For these reasons, Spencer asks the court to adopt procedures for voir dire that allow for a full and complete voir dire of jurors, but also provide reasonable assurance that prejudices will be discovered. Individual or small group sequestered voir dire is the most reasonable method by which this can be accomplished without simultaneously tainting all other potential jurors. In this case, individualized or small group sequestered voir dire is necessary to safeguard Spencer's rights under the 5th and 14th Amendments, due process, the 6th Amendment, fair trial and impartial jury, and the 14th Amendment, equal protection, as well as the corresponding protections of the Arkansas Constitution, including Article 2, 8, 9, 10, 21, and 29. Wherefore, the defendant, Aaron Spencer, respectfully asks the court to grant his motion for individual or small group sequestered voir dire and for any other relief the court finds appropriate. Respectfully submitted, and then his lawyers. So, that's pretty straightforward. They want the potential jurors to be sequestered and questioned individually and not in front of the whole panel, because they're afraid that either they'll repeat what other people are saying because they'll think that that's what people want to hear, or they won't speak their truth, or, whatever. So they want the potential jurors to be questioned individually, which I can't say is a good thing. He's got to get a fair trial. I think he will. And then he can win his sheriff election. Okay, now we have one by the defense for motion to exclude. Motion to exclude evidence concerning cell phone tower data. The defendant, Aaron Spencer, by and through his attorneys Aaron Casanelli and Michael Keel Kaiser of Lassiter and Casanelli, states for his motion to exclude evidence concerning cell phone tower data. 1. Spencer is charged with murder in the second degree. 2. The discovery file disclosed by the state contains allegations that the state can use cell phone location data to decipher the location of a phone and therefore its owner at a given time. 3. While the evidence at issue essentially shows what is already known about Spencer's case, it still must be excluded under Rules 401, 403, 702, and 803. Because this information cannot provide precise location information, it has no relevance and instead will confuse and mislead the jury as to its reliability and the reliability of other evidence, and it will prejudice the defendant while providing no probative value. The most data can reliably show is the general area of the events, which is not in dispute. While the state suggests that this data can pinpoint a phone's location as inside or outside of an area, that is entirely impossible. Number 4, Spencer also objects to the introduction of any testimony or evidence claiming to be able to discern the location of the phone at various times because it does not meet the threshold for scientific testimony. Such evidence does not satisfy the requirements set out in Daubert v. Merrill Dow Pharmaceuticals, and is otherwise speculative, unfairly prejudicial, and lacking in proper foundation. There is no accepted methodology that would support the opinions suggested by the state. Number 5, even at a cursory review that counsel has been able to do between receiving the PowerPoint from the state on Thursday and Monday when the motion is due, on Thursday and Monday when the motion is due, the PowerPoint appears to contain erroneous information about the process and its functioning. The report and conclusions also appear to include and rely on data that has not been provided to the defense. Number 6, the court should not permit any additional supplements of data and should instead exclude this expert testimony at trial for this reason and all other reasons herein and in the accompanying brief in support. Wherefore, the defendant, Aaron Spencer, requests that the state be prohibited from eliciting evidence purporting to give the particular location of a phone at a particular time, including testimony in the PowerPoint presentation and any part thereof, and for any other relief the court finds appropriate. Okay, that's pretty straightforward. And I believe we have one more, which is a brief and supportive motion to exclude evidence concerning cell phone tower. That's the same. It's the same thing, I believe. Oh, this is the actual brief. We can go over this. This one's 12 pages, but at least it'll make my live worthwhile. Worth coming on for, right? So let's see. Oops. Okay, brief and supportive motion to exclude evidence concerning cell phone tower data. The defendant, Aaron Spencer, by and through his attorneys, Aaron Casanelli and Michael Kaiser of Lassiter and Casanelli, states for his brief and supportive motion to exclude evidence concerning cell phone tower data. The discovery file disclosed by the state contains allegations that the state can use cell phone location data to decipher the location of a phone, and therefore its owner at a given time. Footnote 1. The state disclosed this information midday on Thursday, November 20th, 2025, the second to last business day before the motion's deadline on Monday, November 24th, 2025. The expert's CV was provided today, 4th, 2025. Defense counsel are still working on reviewing and analyzing the report and related data. Specifically, the state has disclosed a 12-page PowerPoint presentation with 3 slides showing the purported location of Spencer's phone at various times near the time of the charged act. While the evidence at issue essentially shows what is already known about Spencer's case, it still must be excluded under rules, and then it gives the rules. Any marginal probative value the evidence has, which Spencer does not concede, is substantially outweighed by the very real dangers of confusing the issues, confusing and misleading the jury, and unfair prejudice. Spencer objects to the introduction of any testimony or evidence claiming to be able to discern the location of the phone at various times because it does not meet the threshold for scientific testimony, including the above-mentioned PowerPoint presentation or any testimony based upon it. Such evidence does not satisfy the requirements set out in Dauber and is otherwise speculative, unfairly prejudicial, and lacking in proper foundation. Dauber requires that any specific testimony or evidence be reliable. The focus of Dauber is that any scientific testimony or evidence must be examined on the principles and methodology, not the conclusions. The mere fact that there is a certification does not mean that a particular protocol satisfies Dauber. For example, law enforcement officers may be certified to do polygraph examinations. However, the results of any such polygraph examination are inadmissible in all courts in the state. The proponent of the evidence bears the burden of proving by a preponderance of the evidence that the conditions of admissibility exist. That burden will be difficult to meet here because the state's proposed evidence regarding alleged cell phone location is derived from data supplied by AT&T, which expressly warns that the data is unreliable. The records state, the results provided are AT&T's best estimate of the location of the devices within the specified search. AT&T makes no guarantee as to the precise accuracy or volume of records provided. Please exercise caution in using these records for investigative purposes, as location data is sourced from various databases, which may cause location results to be less than exact. Ooh. The suggestion that such data can pinpoint a device's specific location is unsupported, lacks the reliability required for admissibility, and amounts to nothing more than junk science. There is no accepted methodology that would support the opinions suggested by the state. Daubert set forth 4 non-exclusive factors in determining reliability. 1. Whether the technique employed or relied upon by the expert has been tested, whether the technique has been subjected to peer review and publication, the technique's rate of error if known, and 4, whether the technique is generally accepted by the scientific community. We went through all that in the Karen Reed trial, remember? This, when they were trying to get Dr. Now her name escapes me all of a sudden. Anyway, the ER doctor, when they were trying to get her disqualified as an expert. Why is her name escaping me now all of a sudden? Oh my God. Okay. The state has disclosed nothing related to the above 4 factors. As such, the state has provided no information demonstrating that the proposed testimony satisfies these reliability criteria. Courts have regularly required this information to be presented in court to permit the sitting judge to make a determination while performing the gatekeeping function. Finding error in not holding a hearing to determine the reliability of the methodology for the law enforcement official's testimony concerning plotting the cell site locations on a map. Opining about the reliability of the testimony without a formal Daubert hearing because expert had submitted 4 reports and prior testimony on the subject matter. Courts throughout the country have noted significant issues with using cell records to define cell phone location. As the Missouri Court of Appeals noted in State versus Patton, it is impossible to determine from historical cell site data alone that a phone was closest to the cell site processing call, and at best, these records only indicate that a phone was located somewhere within a cell site's geographical coverage area. A cell phone may be in range of several sites simultaneously, and a multitude of factors influence which site among them will have the strongest signal. The technical features of the cell site, geography, and the workings of the cell phone itself may result in connections from as far to which a phone connects, permits an expansive range of inferences as to where the phone actually is. The Mississippi Supreme Court echoed similar issues in Collins v. State. While the large geographical area that a single cell can cover diminishes the probative value of the cell identification technique, perhaps the biggest drawback of the technique is that cell phones can be associated with cell sites that are not even in close physical proximity. This is because cell phones connect to the cell site with the strongest signal rather than simply connecting to the closest cell site. Among the factors affecting which cell site a phone connects with are 1, the number of available cell sites, 2, whether maintenance on or repairs are being performed on a given cell site, 3, the height of the cell tower, 4, the height and angle of the antennas on a cell tower, 5, the range of coverage, 6, the wattage output, 7, the call volume at any given time and the call capacity of a cell site, and 8, environmental and geographical factors such as weather, topography, and the density of physical structures in the area. Even the PowerPoint presentation itself makes clear that the information contained within it is unreliable. The presentation notes that the phone's call record and list of cell site locations are, quote, used to illustrate an approximate location of the target cell phone for the network interactions, end quote. See attached PowerPoint slide 2, attached as Exhibit A. Further, the presentation notes that the analysis is based upon and relies entirely on cell site location information provided by the service providers and or the National Domestic Communications Assistance Center. Further, the presentation notes that typical cell towers are configured with each sector covering approximately 120 degrees. However, the sector orientation can vary by cell site and service provider. Exhibit B, the presentation notes that a sector illustration shows the general area of coverage as it relates to a specific geographic area, and that neighboring cell sites aid in the estimation of coverage areas for each respective sector. The presentation notes that the cell phone at issue will generally be located within the shaded area, but might be located closer to the tower than the depicted are distance. PowerPoint slide 5 attached as Exhibit C. A murder case is no place for maybes or mights, quote unquote. What is known about using cell site analysis to postulate cell phone location is that there is no way to pinpoint a cell phone's precise location from historical CSLI, and there are no known validation or error rates for the methodologies used to collect and analyze this data. The accuracy of the underlying data provided by the cell service providers is unknown. Rather, the data being analyzed comes from unvalidated records of cellular network operations and unvalidated information about cell tower locations collected by phone companies for network billing purposes. There has been no validation of the cell site data provided by the phone companies either. Further, this analysis relies on the admitted fallacy that cell phones always connect to the nearest tower. Even at a cursory review that Council has been able to do between receiving the PowerPoint from the state on Thursday and Monday when the motion is due, the PowerPoint appears to contain erroneous information about the process and its functioning. The report and conclusions also appear to include and rely on data that has not been provided to the defense. The report also suggests, especially through maps and diagrams, that this data can precisely pinpoint a phone's location as inside or outside of an area when that is entirely impossible. It is one thing to use cell tower data to determine whether a phone is in a certain part of town or in one city versus another, but this data cannot provide reliable evidence as to where a person was within a several mile radius at an exact point in time. Generally, when this type of evidence is admitted, the opinion is far more broad so that the data may be reasonably reliable for that purpose. But here, the data simply cannot substantiate any opinion of Spencer's exact location at an exact moment, and therefore admitting it has no legitimate purpose other than to mislead and confuse the jury as to the reliability of other evidence presented. The produced report paints a misleading and inaccurate picture as to precise locations and oversimplifies what is a complex assessment. Most significantly, the images depicted in the report are highly misleading. For example, it suggests that signal from a cell tower propagates strictly into a 120-degree wedge. In real world, however, cellular antennas' radio frequency coverage consists of main lobes, side lobes, and rear lobes. As illustrated below, using radio planner tool employed by cellular companies for network planning, the depiction of coverage is not as simplistic as a 120-degree wedge. On the left is a real radio frequency plot overlaid with what the state's report depicts, which is to place a 120-degree sector shown in the red lines. On the right is from the FBI's training manual. In real world, the defendant could be as far as Ferndale, which is the opposite direction from where FBI manual relying on 120-degree wedge is pointing. Moreover, the data provided with the report does not appear to include all data used to formulate the theories in the report, as there is data that cannot be matched to the data provided. The defense has requested and is entitled to the underlying data. Not only does the omitted data raise serious concerns about the accuracy of the report, but at this late point, Spencer objects to production of more data and asks for the testimony-based undisclosed data to be excluded. What the data does accurately show about Spencer's movements in the area is already known. So adding this testimony that does not contradict the other information but presents speculative possibilities inserts confusion into the trial, may mislead the jury, and certainly creates prejudice. And because it cannot provide reliable information about precise location, it provides no relevant information for the jury's consideration. As the gatekeeper, the court should not permit evidence that lacks specificity and reliability and which lacks any real probative value. Spencer requests that this court make specific factual findings on the Dauber factors and the following issues. 1. The court should not permit any additional supplements of data and should instead exclude this expert testimony at trial for this reason and all other reasons herein and in the accompanying brief in support. Number 2, the court should conduct a hearing at which it considers evidence relevant to a Dauber analysis and should thereafter exclude the evidence as unreliable. Number 3, should this court find that the proposed evidence satisfies the requirements of Dauber, it should still be excluded as hearsay, lacking a proper foundation, speculative, and violating Arkansas Rule Evidence 403. 4. The state's witness certainly should not be permitted to show the jury a diagram or present any testimony that purport to show definitively where a person's cell phone was located at a particular time. The data simply cannot support that kind of certainty. The court should find that the underlying records are inadmissible pursuant to Arkansas evidence, as they are not generated during the course of business, but rather in response to requests from law enforcement. Further, there has been no foundation laid showing how the records were produced, identified, and or stored. What may be sufficient for the business purposes of cell carriers is not necessarily reliable for the purpose of proving a defendant's location in a criminal case. Some data has not been provided and its source and reliability is unknown. Number 6, the court should find that even if the evidence is relevant, which Spencer does not concede, any marginal relevance is substantially outweighed by the very real dangers of confusing the issues, misleading the jury, and unfair prejudice. Jurors have been shown to overvalue forensic evidence in a way that makes them more likely to convict based on misinterpretation of that forensic evidence. There is a very real threat that jurors interpret this evidence as affirmative proof of Spencer's precise location, despite numerous disclaimers about the reliability and accuracy of the evidence. That is the definition of unfair prejudice. The court must exclude any evidence purporting to pinpoint the location of Spencer's cell phone on the morning of October 8, 2024, including the PowerPoint presentation at issue or any part thereof. Wherefore, the defendant, Aaron Spencer, requests that the state be prohibited from eliciting evidence purporting to give the particular location of a phone at a particular time, including testimony and the PowerPoint presentation and any part thereof, and for any other relief the court finds appropriate. Respectfully submitted. So, there's that. And that's the PowerPoint. And I have no idea how to read any of that, so I'm not even going to try. But it's there in case you guys want to access it. So, those are the latest filings in the Aaron Spencer case. And like I said, anybody that wants to donate can donate it. His Give Send Go. Let me see if I can put it in here. Send go Aaron Spencer. Okay, it's in the chat. So I think that's it for today. Like I said, if I can, I will be back tonight to go over the Kelsey Fitzsimmons hearing, but most likely it will be tomorrow. So I want to thank you again for coming back, and I hope you all have a good rest of your day. Be safe and take care. Thank you.